eminent university trustees, President Thorsett, Dean Bridgman, distinguished faculty, treasured family and friends, esteemed parents, and honored graduates. Watch out! The class of 2016 is about to be unleashed upon the world. I want you to know in the class that we're in the same boat. This is the first time you graduated with a JD, and it's the first time that I've been a commencement speaker. In 1980, I was waiting, just as you are now, to get my law degree here. By the way, I've no recollection of the commencement speech. Since early in high school, I knew I wanted to be a lawyer. Little did I know what was ahead of me. Today, I will share with you 3 short stories and 2 concluding remarks. Story number 1. After passing the bar exam and working for a few months in a Eugene law firm, in March 1981, my wife and I moved to Hermiston in Umatilla County, where I had mostly grown up. I hung out my shingle as a solo practitioner, crossed my fingers, and waited for people to find me. When Catherine Bailey came into my office in June 1981, supported by her husband and 3 children, she was gasping for breath and had an oxygen tube tentatively strapped behind her ears and into her nose. I was 28 years old. She was 38, looking like a frail 65-year-old. She said her lungs had been damaged from working in a fiberglass boat factory in Central Oregon, and now she was totally disabled. Showing how smart I was, I told her I could immediately file a claim for her. "Oh, I already did that," she said. I quickly recovered. "Well, if you get a denial, we can request a hearing." "Oh, they did issue a denial," she told me. "I used to have an attorney in Portland, but he resigned." A quiet alarm bell started going off in my mind. I told her we only had a limited time to request a hearing, but I would be happy to help her. "We already had a hearing," she explained. "You mean you represented yourself?" My voice may have risen an octave in tone. Her husband interjected that he didn't have much regard for lawyers anyway, and he thought they'd done a pretty good job. Not noting the irony, he concluded, "We lost at the hearing, but would you help us with our appeal to the board?" The alarm bell in my brain was now clanging loudly. The difficulty, of course, was that I knew the board only reviewed the evidence produced at the hearing. But you understand I was far from having a full client load at that moment, and so I took the case on the standard contingency fee arrangement. It was also the only way she could afford a lawyer, since her much older husband was unemployed and the family lived on her Social Security disability of $700 a month. I learned they lived in a small trailer house stuck on 7 acres of sand just outside of town with no electricity and no running water. When I got the hearing transcript and the medical documents, I was shocked to see how little causation evidence there was. The few doctors who had examined her agreed that she had severe lung disease, but they were silent on what had caused it, since no list of chemicals she had been exposed to had been provided. And they had never been properly asked for an opinion in line with Oregon's definition of an occupational disease. Since no new evidence could be directly added at the board level, I saw no likely way to win the appeal based on the evidence in the record. Oregon law, however, allowed the board to remand the case back to the hearings officer for further evidence if the case was, quote, insufficiently developed. So I started developing evidence. In answer to my question, one of her doctors said that the work exposure, quote, was a material contributing factor in producing her present respiratory condition. I also submitted the records, such as they were, to a professor at the University of Washington School of Public Health, and he wrote, quote, there is no doubt in my mind that her employment in the boat plant was responsible for her present respiratory condition. So in September 1981, I filed a motion to remand in order to present additional evidence. Then we waited. Finally, on April 30, 1982, the board issued its decision denying the motion to remand, saying that its recent decision to restrict its discretion to a more narrow standard than the statute was controlling. We appealed to the Court of Appeals, which in December 1982 affirmed the board order without opinion. So for the first time in my brief legal life, I appealed to the Supreme Court. On March 8, 1983, the Oregon Supreme Court denied our petition to review. I was deeply disappointed. An injustice had been done. In writing my briefs, I had quoted from an old 1933 Oregon Supreme Court case. Quote, "We still cherish the notion that the real purpose of establishing and maintaining courts is not to enthrone technicality, but to vitalize and render controlling the principles of justice and equity." I liked that sentiment. Catherine Bailey was dying, but what more could I do? I did not sleep well. Finally, with all time running out, I decided on one last desperate action. I would ask the Supreme Court to reverse itself. So it was that on March 29, 1983, I filed a petition for rehearing the court's denial of the petition for review. Here is my entire petition that I wrote on a single sheet of paper. Quote, "Claimant prays that this court reconsider its denial of claimant's petition for review. The board is wrong in relying on OAR 436-83-700 sub 5 to limit its obligation to remand pursuant to ORS 656.295 sub 5. This case is tragically and clearly incomplete in the record developed at hearing. The evidence submitted to the board and the Court of Appeals should be considered, and thus this case should be remanded." For 3 weeks, there was deafening silence. Then on April 19, 1983, the Oregon Supreme Court reversed itself and allowed the petition for review. Even today, I don't know why or how this happened. I like to think that the principles of justice and equity won the day. What I know, and what I'd like you to remember, is that if I had not filed those 4 sentences, this case would have ended in total defeat. Oral arguments, my first before the Supreme Court, were held on June 8, 1983, nearly 2 years after I had started to represent Mrs. Bailey. On November 15, 1983, the Supreme Court reversed the Court of Appeals and the board on the issue of the proper standard for remand, noting that the board had, quote, "scrambled the legal eggs." I was ecstatic. We'd won, but we'd really only won the opportunity to try and persuade the same board who denied a remand in the first place that they should now remand the case pursuant to the statute, which was discretionary. Finally, on March 23, 1984, the board agreed to remand the case, saying, "We agree with claimant that this case was improperly, incompletely, or otherwise insufficiently developed at the hearing. It had taken nearly 3 years. Now I could actually start to properly investigate what had happened, depose witnesses, ask the right questions." Tragically, before we could get to a hearing, Catherine died from complications of her lung disease. We settled her claim for an amount that would pay for college for all of her children. We got the check almost 5 years to the day that she came into my office. My contingent fee worked out to about $5 an hour. My conclusion: perseverance does not guarantee success, but success is usually impossible without it. Story number 2. With the Catherine Bailey case going on in the background, in late 1984, I was reading the Wall Street Journal and learned that the aluminum smelter in the Dalles was going to shut down. A local group was trying to save the smelter, and I called them to offer my help. Being able to say I was a lawyer helped to get my foot in the door and is another value of being a lawyer. That effort, however, failed. After a much longer story that I don't have time today to tell, in 1987, with the help of many others, I eventually negotiated the acquisition of a much larger smelter situated in Washington near the John Day Dam, negotiated the associated labor contract with the United Steelworkers of America Union, sold 1 billion pounds of aluminum to the largest industrial company in Norway, put together a consortium of banks to fund the deal, and became the majority owner while creating a new employee stock ownership plan. I came from completely outside the industry, as Dean Bridgman mentioned, and I just had no idea that this was impossible. My legal training and trial lawyer experience helped me to study and understand the various necessary pieces of the puzzle, seek the appropriate expertise I did not have, and yet not defer automatically if others, including lawyers, advise me to quit. I repeatedly learned that sound legal advice is crucial, most of which I obtained from the Ader Wynn law firm that Steve Wynn was associated with at the time. All of this helped me see that practicing law is not the only good use of a law degree. In 1989, I decided to become a full-time entrepreneur, so I became an inactive member of the bar. In 1995, I divested the smelter, and Columbia Ventures, which then owned several extrusion and recycling plants, became an independent company that I owned. After investigating several possibilities, in 1997 and 98, Columbia Ventures built a new state-of-the-art aluminum smelter in Iceland. This project required negotiating with the government of Iceland for the land, permit, and electricity, as well as local and international engineering and construction companies, national employee unions, and a plethora of bankers and vendors. Again, I felt that my legal training and experience provided a positive and constructive background for these activities. In the new millennium, I started thinking about a new distressed area, telecommunications. In 2003, I bought out of bankruptcy a brand new submarine fiber optic cable system headquartered in Dublin, Ireland, connecting Canada, Ireland, England, and America. This was the start of Hibernia Networks. We also invested in other East Coast and European telecom assets such as Magnet Networks as a complement to Hibernia. Again, while I was not a legal expert at all in these various jurisdictions, my legal training from Willamette was put to good use in a number of important ways. Then came the financial meltdown in 2008 and subsequent Great Recession. Columbia Ventures nearly imploded when our Icelandic banks collapsed, as you may remember, and it was impossible to obtain other financing. In spite of these difficulties, we continued to look for ways to create uncommon value, and in September 2015, Hibernia completed a $220 million project, laying the first new transatlantic fiber optic cable in a dozen years. Story number 3. In late August 2014, while working on the Hibernia transatlantic project, I was diagnosed with Hodgkin's lymphoma, a cancer of the lymphatic system. To say I was surprised would be a massive understatement. But the biopsy, CT, and PET scans were definitely positive. I had just turned 62 and attributed some of my subtle symptoms, like getting tired more easily, to getting older. I now know that was not the cause. But a diagnosis like this does concentrate the mind and cause one to question, what are the really important things of life? In my case, I decided they were God, family and friends, and trying to help build a better future. Once again, my legal training kicked in to help me become educated in another area I knew little about. This included things like research, careful thinking, and weighing risks and rewards. I learned that I was lucky because Hodgkin's is usually very amenable to curative treatment. The standard treatment had proven to be effective, but with the risk of potentially serious side effects. Given the huge amount of recent cancer research, I looked for drug trials that had high promise of great results without as many side effects. I learned that Seattle Genetics had created a new chemotherapy which had produced amazing results for those who had failed the standard treatment. The FDA had approved the drug quickly for such situations, but still did not approve it for someone like me who was looking for a frontline treatment. A new clinical trial, however, combining the new drug with one of the standard 4, had started specifically for those recently diagnosed over 60 who had never been treated. I'll just mention that I guess the idea was if they lost a few of the old guys, it didn't really matter that much. I had consulted with 3 different oncologists, which in my lawyer life, they would have been the expert witnesses, and decided to join the trial as the 19th of 20 people in the world. I also decided to blog about my experience in case it could be helpful to anyone else. After only 2 chemo treatments, I achieved complete remission, as they call it, just in time for Thanksgiving. I went on to complete a total of 9 treatments, ending on May 4 of last year. Most importantly, I remain in complete remission. The only annoying side effect is a slowly resolving peripheral neuropathy in my feet and hands, and I'm feeling it a little bit in my feet particularly now. Hopefully the data from this clinical trial will help prove that a highly effective new treatment with fewer toxic side effects is available. Now I'm concluding. You are about to get a piece of paper you have worked so hard for years to obtain. When I was in your place, I thought I would be a lawyer practicing in Eastern Oregon. That turned out to be only a short part of my life. But the lawyerly way of thinking critically and carefully, studying the actual facts and the law, instead of just assumptions about a situation, and being a zealous advocate for something you believe in, are crucially helpful in many endeavors. My advice, be curious and open to new things that you have never imagined, and never forget that one person can make a difference in the world. I want to close with a wider appeal to everyone here. As a law student, I often went to the state capitol, just right there. And there in the rotunda area, you may also have seen these words chiseled in stone. In the souls of its citizens will be found the likeness of the state, which if they be unjust and tyrannical, then will it reflect their vices. But if they be lovers of righteousness, confident in their liberties, so will it be clean in justice, bold in freedom. Whatever else you do, wherever else you go, however your life turns out, let us never lose our love of righteousness or our confidence in liberty. Thank you.
Ken, thank you so much for your inspiring address. Thank you for being an exemplary role model for us and our students, and thank you for being such a great friend to the College of Law. To memorialize this occasion, I would like to present you with a small gift on behalf of Willamette University College of Law, and especially this graduating class.
Great. Yeah. Thank you.